Hey there, lovely listeners. Isn't it awesome how the wedding and event industry keeps going year after year, even with all we've dealt with over time? With more clients continuing to chase their ultimate dream weddings and events, the energy in this space is truly something else. Interesting here is that I often see when hosting larger events and weddings that having a full service event planner to step in with all-inclusive packages is a game changer for those clients who want to kind of sprinkle their personal touch to their big day without getting tangled up in the nitty-gritty execution. They leave that to the event planners. You know what's also cool? Some planners go the extra mile, becoming the go-to communicators and even contract signers with vendors, taking that load off of their clients. But guess what? We are going to explore the super intriguing topic today here on the Legal Paige Podcast about why, in most cases, legally speaking, planners might want to hit the brakes on signing those vendor contracts on behalf of their clients. Yep, you guessed it, there are some serious legal angles to consider. Legal liability and risk management being a key one. So let's jump right in and get this conversation rolling.
You're listening to the Legal Paige Podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. I am an attorney, but I am not your attorney. All legal information I talk about in this episode is intended for the masses and a large variety of different businesses. Please seek out another attorney in your city and home state if you need specific legal advice related to your unique business. Okay, let's get back to it.
As I mentioned in the intro, it's definitely become a popular trend to start offering all-inclusive packaging as a wedding planner, and particularly a full-service wedding planner, for clients who want to have input for their event and probably their wedding, but don't want to be involved in the execution in any way. Legally speaking, though, planners should consider not signing vendor contracts on behalf of their clients in most instances. All-inclusive planning packages are, of course, they're a great way to relieve stress for your clients, make it easier on the planning process all around. There's certainly value in offering your clients this kind of package, but signing contracts on behalf of your clients, in my honest legal opinion, should not be included in your services. And again, there's always a caveat, but this is like 90% of wedding planners. I don't suggest doing this. Signing a contract on behalf of another person is much more complicated than one might think. You cannot sign on your client's behalf simply because they told you you can. Instead, you need a signed power of attorney, giving you the authorization to sign contracts, particularly these type of client-to-business contracts, on behalf of your clients. And usually they also need to be notarized because you're just a POA. And if you don't have that notarized POA, any contract that you sign on their behalf can be deemed either 1, a contract with you and your planning business instead of them, 2, void altogether in the eyes of the law, or 3, even be deemed as fraudulent practices. Yikes. Like, why do you want to get into that situation? Even if your clients are willing to sign a notarized POA, which is power of attorney, and then you can legally sign on their behalf, the question is really, should you be signing on their behalf and taking on that risk? I want to express all of the legal reasons behind why I think best practice is no, don't do this, and why I strongly advise against ever signing on your client's behalf. We have planners that ask this question to TLP, whether it's in our support inbox or whether that's in the Legal Paige community online. And myself and my legal team always come back with the answer, we really just don't suggest this. But I wanted to lay it out into a why and because. And I really want to give you some scenarios on how this just isn't a good idea. Because the lines of who the client is and who is liable to the vendors if the worst happens, think, of course, cancellations and reschedulings, but what about a natural disaster or someone gets injured or hurt or negligence occurs on your behalf, on the client's behalf, on a vendor's behalf? All of that becomes really blurry. You don't want to be stuck in a situation where you're fighting with not only your clients, but also the event vendor on who is liable when the worst happens. Like there's immediate joint and several liability, which is what it's called in the legal world. You're like signing yourself up for that. And we're trying to help you avoid being on the hook for those types of sticky situations, particularly the ones that are just between clients and vendors. You're just really the intermediary. You shouldn't be the one contractually obligated to anything. So here are some examples of what could legally happen. For instance, if your clients cancel their wedding a day before the event and your name is suddenly on all of these contracts because you signed them previously, these vendors are probably going to sue for non-payment so say like your clients don't pay these final invoices or maybe not all of them. They're going to sue you and your business for non-payment. And the clients, you're both going to be co-defendants probably on a complaint, a legal complaint. And then you're going to have to hire a lawyer and potentially drain your savings to get this resolved. And you're going to be fighting with the clients because it's not as easy as like, I'm just not on the hook. Like you have to litigate and say, a motion to dissolve. Like I shouldn't be a co-defendant in this case. Also, you're never going to see that money again when you're paying for legal fees and costs. And ultimately, sometimes it's best once you start adding up those costs, you're like weighing, should I just step in and give the refund and then deal with my clients later? Or let's say you've signed your client's vendor contracts and facilitated payments for them, but then this vendor maybe cancels before their event. And now you're the one stuck trying to get refunds because you're legally bound by the contract. On the flip side, let's say a vendor cancels on your client. If you're the one who's listed on the contract, you're now having to facilitate getting your client's money back. And you may even have to go to court to get their money back because you're the only one with legal standing to bring a case in front of the judge because you're the one on the contract, not the clients. All the while, you have an unhappy client who lost a vendor and hasn't seen their money yet, and you're still trying to figure out the nuances of executing and planning this wedding and event. On another note, if your clients decide to reschedule, perhaps, and vendors decide to charge rescheduling fees, you're probably going to be the very first person that they contact to sign those new contracts and pay those rescheduling fees because you signed the original agreement versus again, being the medium there and the person explaining to the clients like why this is, or maybe renegotiating a fee on behalf of your clients for this rescheduling with the vendor, but then the vendor is still sending the rescheduling agreement or addendum and the invoice to pay for that rescheduling fee directly to the clients. Like you are not involved. All of these examples are very real and clearly can cause you more of a headache than necessary if you would have just had your clients sign their own contracts. Okay, so that was me conveying some situations to you in everyday layperson talk. But in lawyer speak, here are some legal liabilities that you're taking on. And I just want to list them out because there's a lot. Wedding planners are like, but why? But why can't I do this? 1, financial responsibility. We've talked about this. By signing a contract, you as the planner are likely going to become financially responsible for fulfilling the terms of the contract. If the vendor or the client suffers financial losses due to a breach of contract, you're going to be held liable for those losses. Personal obligations. You as the wedding planner might inadvertently agree to performance obligations either outlined in the contract or verbally agreed to, like it's a tertiary agreement to the contract. And then if the vendor fails to meet those obligations, you are legally responsible for ensuring the vendor's performance, even if they have limited control, even if you have limited control over the vendor's actions. Of course, a breach of contract. If the vendor believes that you haven't upheld your contractual obligations as a planner because they're the ones that signed it with you, they might pursue legal action against you for breach of contract. Or vice versa. If they breach, then you have to pursue it against them. You're the only one withstanding, like I said. Obviously, litigation, damages, tarnished professional reputation, just all of that on the line is not a good idea. Indemnification and liability. So contracts often include indemnification clauses. We kind of know that word. I have resources on it at thelegalpaige.com if you need more information surrounding what indemnification actually is. But ultimately, it shifts liability from one party to the other. So if you as the planner have signed a contract, you're legally obligated to indemnify certain people, probably the vendors, in the case of certain disputes, claims, or damages. Not the client, you. You have to indemnify. Just not a good idea. Errors and omissions. If you, as the planner, make a mistake while signing the contract, or say you fail to accurately communicate the client's wishes to the vendor, i.e. an omission, it would result in errors that could lead to legal disputes between the vendor and the client, but really it's just between the vendor and you. Negligence claims, of course, that's the biggie under any type of service agreement, is just negligence, the what-if scenarios on things that could go wrong that are outside of your control. To the best of your ability, you try not to have them happen. So we're not talking about intentional acts here. We're talking about negligence claims. When negligence leads to financial losses, whether that's for the vendor or the client, you're going to face the legal claims of negligence. Conflicts of interest. This is a biggie. And I see this as one of these like glaring red flags when you're signing a contract on behalf of a client. It's going to create conflicts of interest for the planner. If your interests clash with the client's, it could lead to legal challenges related to like ethical concerns and fiduciary duties for you. And if there's something involved with, a commission split, or you have some relationship with this vendor that results in, financial gains for both of you, but it's not your client signing the contract, it's you. It's just like massive conflict of interest issues. And then unauthorized representation. If the client didn't explicitly authorize you to sign on their behalf, a notarized POA, you're probably engaging in unauthorized representation, and that is a lawsuit in and of itself. Okay, so I talked about like real case scenarios, and then I also just talked about the variety of like claims that could come up with you signing on behalf of them. Here's what I suggest as your friendly attorney that you could offer instead. You could still offer your clients an all-inclusive package, but request them to meet you in person or virtually for a contract signing day. You'll be in charge of going through the contracts, reviewing them, of course, negotiating contracts prior to that signing day with the vendors, really being that intermediary, offering the clients guidance on these contracts and, pre-negotiations, and then get all the final contracts in place back from the vendors and ready to sign. Then the clients sign their contracts all at once with you assisting them. Think of it similar to a real estate agent helping their clients navigate and draft up contracts, but the homeowners are always the ones signing. Those real estate agents are never going to sign these types of things, and that way the client's signatures are on the contracts and they alone are liable for XYZ terms in the contract. But you are really just providing that quality, all-inclusive service of organizing, gathering documents, and ensuring that there's no glaring issues present. Because you have more experience looking at vendor contracts like this, understanding the wedding and event industry, working with clients or working with this particular vendor and knowing what wiggle room there may be with this, particular client-vendor relationship. All in all, not only will you be better protected legally by doing this and not having your signature on the bottom dotted line, but the vendors also feel better knowing that you merely assisted and that they have a clear indication of who their actual client is from the get-go. The only, and I mean only, exception to this is with high-profile celebrities or government officials or just people in general who have lawyers in place that draft up extremely clear POAs for you to sign and execute documents anonymously on behalf of your clients. It's kind of like the anonymous event for somebody. The vendors don't totally know. Maybe they have an indication of it. But this always involves a lawyer. So there is a client lawyer that is there. And you probably need to have a lawyer involved as well to review these types of documents before you sign on with the client. I don't want you agreeing to something or signing something on behalf of the client without your lawyer and their lawyer agreeing on the clear terms of what that is going to entail. I see this with really high profile wedding planners. So, if you're in that realm or you're trying to get into that realm, I would highly suggest you get mentored by one of these high profile wedding planners and get a full understanding of what this type of anonymity type of NDA, POA signing would entail. Switching gears a little bit, I want to talk about from a vendor standpoint. This part is for you. What do you do as a vendor when an all-inclusive event planner says, hey, I'm going to sign on behalf of these clients? I have heard from countless individuals and service providers that maybe they're talking with clients, but then the clients know they have a full-service wedding planner on board, and then they're approached by the wedding planners who are now ready to sign the service contract on behalf of clients. It's just a weird situation to get into because I think your clients know that the wedding planners need and want to sign, and that's what they've agreed to. So they want to put that execution task on them. But it's my legal opinion that not only is it a bad idea for you, but the only people that should be signing your contract are the clients, not their parents, not their aunts and uncles, and definitely not their wedding planners. It is your client's responsibility to pay you, to uphold the requirements on the event days. Of course, you're going to work directly with the wedding planners day of and on the event days, but you're ultimately servicing your clients. Final deliverables are for your clients. They're not for the planners. The planners are just in the middle. They're just the ones helping to facilitate the event. Why? Why is this such a bad idea? Well, when a planner signs a contract on behalf of a client, there are also a lot of legal situations that could arise. First and foremost, lack of authority. If a planner is signing a contract without that authorization from the client and you don't know as a vendor, that's the problem. On the flip side of it, you assume that they've all agreed to this and there's some POA and they're allowed to do it. What if that isn't actually the case? Then questions come about regarding the legitimacy of the actual agreement as a whole. Nobody had the ability to actually sign that with you. The client might later argue that there's, no proper authority, leading to contractual disputes, leading to no money being paid. Bad situation for you. Also, miscommunication. Of course, the planner and the client need to be on the same page, but ultimately, if there is a final decision that needs to be made and it has a lot to do with your particular services you're offering day of, that needs to be communicated by the client. Again, the wedding planner might be able to explain what the client's wishes are, but if you need final approval, you need to get that from the client, and you wouldn't be able to do that if the contract is signed by the planner. Liability shifts. When the planner signs the contract, they're of course taking on certain liabilities that the client would otherwise have. And this complicates matters if issues arise during the event or in the aftermath of the event. And it might not be clear who's legally responsible for what. Indemnification and liability clauses, same thing goes here. If a vendor's contract, your contract, contains clauses related to indemnification, limits of liability, insurance requirements, maximum damages, the planner might unknowingly agree to these terms that the clients actually needed to agree to. And like I said, it exposes the planner to unforeseen legal risks, but then you can't actually go to the clients for this. And you're just in this weird confusion of who agreed to what. And these are really important clauses in your vendor contract that you want the clients to sign off on. What about termination? In the event of the contract termination or cancellation, that is the biggie. The planner is probably not going to have the same rights as the client would to terminate the agreement under specific circumstances. So it's just in your best interest for you and the client to deal with cancellations and reschedulings together and signing, next steps or signing off on how you're going to solidify that termination. Of course, with a planner's opinions and considerations and, their help working with the client. But ultimately, those types of things should be agreed to upon by you and the clients. Dispute resolution is a big one. If a dispute arises between the vendor, you, and the client, the terms of the contract might dictate how disputes are resolved, and the planner might not be privy to these same preferences as the client would be, regarding arbitration, mediation, legal action, anything along those lines. And then modifications to a contract. Making changes to a contract, particularly your service contract, after it has already been signed is much more complex if the planner is the signatory. Changes might need to be made quickly and efficiently, and probably with the client's direct consent and approval, an explicit consent and approval, which is probably already written in your contract that nothing is changed unless the parties are signing like a written agreement to change it. So a contract amendment. All in all, with a planner involved, it just slows down the process. And it's, of course, going to lead to misunderstandings, especially when modifications and changes are involved in an original agreement. And then finally, just confidentiality and privacy. Contracts oftentimes contain clauses about any type of model releases or likeness, use of, the client's professional photographs for your own advertising and marketing. If, you're allowed to maybe try to acquire those from the professional photographer. If they have any model releases that are signed for you, doing any type of social media behind the scenes of their wedding and event on your smartphones and then posting that on your accounts, that all needs to be signed off by the client, not the wedding planner. So the key here is getting the clients to sign. But you have to be polite and professional, but firm when a wedding planner is saying, hey, I'm supposed to sign on behalf of my clients. You need to explain, of course, that you're happy to work with this wedding planner on all things, future planning, communication, so on and so forth. But the legal contractual obligations need to remain with the clients. And in the event that you receive a request like this, here's a potential response. And I'll make sure to put this in the show notes for you so that you could just copy and paste it. Thank you so much for reaching out and inquiring about my services. I'm excited about the possibility of working with your clients for this event. If they would like to book with me for X services on X date, I will need the client's contact information along with their signatures for this attached contract. It's my business policy that the clients are the ones who sign the contract. I'm, of course, happy to continue to include you in all communications and plans as long as I receive written confirmation from the clients to do so. Thanks so much, and I look forward to working with you. Just something like that, something really simple. So you explain, this is your business policy, you're kind of holding your ground, you're being firm, but you're also stating, I'm going to work with you moving forward. You're the planner. I really want to talk to you and make sure everything's good to go prior to all of us putting on this awesome event. So hopefully as well, this helps you earn respect in the event industry and will establish for planners and clients that you're trusted for their event, that this is the way that you perform services, and future-wise, working with them becomes much more easy. Now, of course, if the wedding planner still takes issue with the client signing, then the next step would be simply to ask for the client's lawyer's contact so that you can ask the lawyer directly. Again, don't take it verbatim from the wedding planner. You need to make sure that the lawyer of the clients has told you legally that they have executed proper documentation, which gives the legal planner the legal authority to sign the contract. Lawyers know how to navigate this issue while maintaining important confidentiality concerns if their clients are requesting such types of confidentiality. So again, it's you're not just taking what the planner says, you're just saying, I understand if this is what's really going on, just can I talk to the attorney? So that again, you have things in writing if something were to go wrong, that the lawyer has told you, yep, this is executed, this is how it's going to go down. All right, we've gone into everything that I wanted to get to in today's episode regarding event planners. offering all-inclusive packages and why, from my perspective as an attorney in the wedding and event industry, that there's a solid case for planners to carefully consider refraining from signing on their client's behalf in most scenarios. Plus, we've also explored some savvy moves for vendors when facing this situation. Now, let's circle back and highlight the key insights from today's chat. As planners, you can absolutely provide these types of all-inclusive packages while keeping everything on the up and up legally. Remember, signing on your client's behalf just because they gave you a nod isn't the way to go. You need a notarized, rock-solid power of attorney that spells out the authorization to do so and sign. And even then, you have to remember you're taking on so much liability and risk. And if you're a vendor, we've gone over the reasoning behind why legally you shouldn't accept a signature on behalf of a wedding planner and how to effectively and kindly communicate your business policies surrounding only clients signing your vendor contract. So whether you're a vendor or a planner, here's my golden nugget. Use contracts that are the real deal. It's absolutely your safety net against any of these what-if crazy scenarios that might and will certainly come your way at some point in your business trajectory. For planners, you want to have that top-notch wedding planning contract. It's not just a formality, it's your way of setting clear boundaries and safeguarding yourself from all of the unexpected. And you're going to deal with a lot of the unexpected in the planning world, let me tell you. And vendors, don't let your specific vendor contract pass you by. At the Legal Paige, we do have all kinds of contract templates that are crafted specifically for your unique business. We've worked with industry professionals that are experienced, that have years and years of all of these what-if scenarios actually happening to them, and we make sure to safeguard and protect you from those with all of your clients in these template contracts. So all of our template contracts at thelegalpaige.com are the secret sauce to running a professional, legal sound operation. And if you're ready to level up, just head over to thelegalpaige.com, that's thelegalpaige.com, and find the tailored contract that suits your expertise. All you need to do is click the Shop by Industry drop-down arrow on our nav bar, and you'll see all of the industries that we serve and have template contracts for. That's all I have for you today. Go ahead, empower your business, and make sure that you are protecting your passion. See you in the next episode.
Thanks so much for listening to this episode of the Legal Paige Podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpaige.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.